So joining us to break down the decision is KUSI contributor and criminal defense attorney Vic Bajaj. Vic, good morning to you, sir.
Good morning as well. Thank you, Lauren.
So maybe you can expand basically what the Attorney General Cameron was saying there about the fact that to many people's disappointment, no officer, not even the officer who is facing the charges of wanton endangerment, were charged in Breonna Taylor's actual death. Maybe you can explain Kentucky law, which says that because these officers were justified in their shooting, they're not going to face charges.
Yes, absolutely. And it's really something that's consistent throughout the union, that is all the states in the United States of America, and it's self-defense. And as Daniel Cameron, the Attorney General there in Kentucky, who we just heard from a bit ago, made very clear at yesterday's press conference that each one of these officers had a justifiable and a legal right to exercise self-defense. And this is specifically, Lauren, because Mr. Walker, who was Breonna Taylor's new boyfriend, shot the first shot and hit the officer in the leg. And so then anything that happened after that use of fatal force would be within the umbrella or the bubble of an adequate legal exercise of self-defense. So this means that the bullets that went from law enforcement side and unfortunately struck Ms. Taylor are of no consequence under the law as far as a criminal prosecution is concerned.
In regards to the warrant, which has come up a number of times, this no-knock warrant, the Attorney General made specific to note that based on the testimony from the officers as well as a witness in the apartment complex, that those officers did knock on the door. They announced their presence, that they were officers before kicking the door in. Does that change things? Will that change law moving forward? How is that going to be affected down the road?
I don't believe it'll change things insofar as a criminal prosecution is concerned, Lauren, but it may change things insofar as a civil rights investigation that's being headed by the FBI now is concerned. And that is because in this case, we understand the judge who authorized the warrant authorized that to be a no-knock warrant, which means they did not have to give the residents or occupants of that home any notice. And the reason for that, Lauren, is because we don't want, law enforcement and courts don't want suspects who may be involved in criminal activity to dispose of evidence or to take any actions that could further endanger the safety or lives of the officers. So having a no-knock warrant is not anything new by any measure. It's something that happens in a lot of narcotics cases and cases that involve firearms or any propensity for violence for both of the reasons I've outlined earlier. So the no-knock portion of it, and you're astute in pointing out that the Attorney General there in Kentucky takes particular issue with this. They believe, that is, the state of Kentucky believes that notice was given, that a knock was given, and they have an independent resident in the area who confirms that. So will that be a consequence? I don't believe it will be a consequence on the criminal side. It may, however, be a consequence in the federal investigation side, which is surrounding around a civil rights violation potentially.
Yeah. It seems there's so much disappointment surrounding this. I mean, we've seen the protests come from this. People really wanted someone to be held responsible for the fact that Breonna was shot, and none of the charges are relating to that. And they haven't even determined which officer's gun was the fatal bullet that killed Breonna Taylor. And is there anything that can come of that or can change that? I mean, it seems as though, and you could kind of hear in the Attorney General's voice that, justice has to fit within the law. And because of Kentucky law, that just wasn't going to happen.
Oh, that's absolutely correct. And you actually dovetail into an interesting point. The only person that could, under any theory of law throughout the United States, be held culpable or charged with the murder of Breonna Taylor would be Mr. Walker. Mr. Walker needs to be very lucky that he's not in the fine state of California. we have what's called the provocative act theory of murder. That is, if you do something that reasonably causes a reaction by another individual, which then causes a death, you yourself are liable for that death. So if Mr. Walker was in California, you bet your bottom dollar that the district attorney's offices, in whichever jurisdiction that would come forward in, would consider a murder charge against Mr. Walker. Now, the provocative act theory of murder has been strained through the appellate courts as of late up until 2014 and 9 with potential really important rulings, but it does not carry water in many states, primarily in this case, Kentucky. So nobody can be held guilty or culpable of a murder when the murder was justified. Now, playing the tune of the public arena is a different issue, but that's not the job of law enforcement, and that's not the job, surely, of the Attorney General's office.
Yeah. Is there anything that you think could or should change because of this case, Vic?
I think, having handled no-knock warrants and search warrant litigation for, the better part of 20 years now, I can tell you the no-knock portion of it raises significant considerations for danger. We know that the settlement has been reached with the Taylor family in regards to the death. I think it was $12 million paid by the city. Part of that are changes in the way that warrants are executed. I don't think there's a downside in improving the intelligence that's gathered, meaning up to minute or up to second intelligence before knocking on the door or before knocking the door down. This has created an enormous amount of violence throughout the communities, justifiably in many cases, but sometimes not. I think that's something we can look forward to being an improvement nationwide as a result of this unfortunate incident.
All right. Well, Vic Bajaj, certainly appreciate your expertise in this area, and thank you for joining us again this morning.
My pleasure. Thank you, Lauren.
Take care.